Welcome here tonight. My name is David Boeren and I work for Studium Generale here at our university. We organize all kinds of lectures, debates, film screenings, cultural events, and much, much more. And today we are going to talk about something which has been dominating the news cycle for the past years, more prominently than before, and that is war. Think of Ukraine and Russia, Palestine and Israel, and also Lebanon. We've heard much about these conflicts and the role of international humanitarian law in them. We know that these laws are supposed to be a set of rules that protect and limit civilian casualties, but in practice, we seem to be hearing more about fighters and their commanders transgressing these laws than adhering to them. This then begs the question, what is the point of international law in war? Our speaker tonight will try to answer that question by looking at current conflicts through a legal lens. We'll first listen to her lecture and then we'll have ample time for questions after. She's Associate Professor of International Criminal Law at the University of Amsterdam, and in her research and teaching, she focuses on international law, international criminal law, national prosecution of international crimes, and human rights. Please welcome on stage Dr. Marieke de Hoon.
Hello, everyone. Woo, I'm loud. Let me take one sip. Thank you so much for having me here, Erasmus, and of course you for all coming here. This is obviously a really difficult topic, and I don't mean it that like it's my expertise. I get to spend every day thinking about it, but still, it's difficult times to be an international lawyer. And after being invited to this, it was a couple of months ago, and back then I thought, yeah, of course, we're going to talk about a few things, but then things happened over the summer, and then I thought, oh, maybe I should do it a little differently, and then more things happened. And then I woke up this morning, and more things happened. And so today I'm going to say things that I think that today are important. But unfortunately, maybe if we do this 1 week later again, there is so much more to talk about again. And David already said that we're talking about international humanitarian law. But with the news of this week, with all the bombings on Lebanon, by Iran, on Israel, I have expanded the scope and spending a little bit more time also on the use of force, because it's important to understand both, to understand these types of conflicts, as well as the law, some bit of the law of occupation. So it really is international law in war, and I think what every international lawyer nowadays is thinking is, what is the point of it? What are we doing? How hard is it? And I have an answer for me, and that is that I do think that it is better than nothing. And that is what I hope also that you come out of this with. So the short answer is today it is tempting to say there is no point. No one seems to care. Everyone's just killing civilians all over the place. Everyone's just invading other countries. We have laws. They all say, short, quick answer, they say no, you cannot. But they do it. They don't seem to care about all the human suffering anymore. But of course they do care, but I don't know. But I do think that international law is developed to create stability, and it's to prevent all-out war and human suffering, and I do think that even today we still must understand that it's better than nothing and fight harder than ever. And you, I see many students here, you are the next generations. You need to help, you need to jump on, you need to help us improve this law, improve compliance by states with law, and try to improve law also that it reinforces less injustices, as it always also does. How many of you here study law, have studied law, have some knowledge of law? You, yeah. Are there people that study international law? Studied it, yeah? Work in international law, human rights, or international criminal law? I see a few. Great. Are there people that have no knowledge of law? Also a bunch. All right, good. So I'll try and make it as simple as possible. It isn't simple, so that means I also sometimes just say things and I say yes and I say no, and obviously with all of that, it's way more complicated. If you want to know more, come study international criminal law, international law. You have great programs here, we have it as well at the University of Amsterdam, but I can't do all that in 50 minutes. So it really will be like a really sort of quick, to get some basic understanding of the key features of the law that applies to the situations that we're seeing right now. So, some key international law doctrines. So I'm going to dive in, I'm going to be super fast, maybe, but if you don't follow and I see eyes, like I'll not be so super fast. We'll see how it goes. There's a Q&A after, and I'm happy to talk more about these things then as well, of course. And if there's like really something like, I don't get it, do raise your hand. Let's try not to have too many discussions, because then we get nowhere until sort of the end. But if you feel like expressing, feel free, I don't mind at all, as in I welcome that as well. So, a very important thing to understand if you're looking at the news is that there is a distinction between the jus ad bellum and the jus in bello. We lawyers love our Latin. I can't say anything else. So, jus ad bellum is the question on using force. So, using one state using force against another state on another state's territory. The jus in bello is the law that applies in war. So when you're looking at, for instance, Russia-Ukraine, the invasion of Russia in Ukraine is a violation of the jus ad bellum. The way that that war is fought, by attacking civilians, are violations of the jus in bello. So the kinds of weapons you use is jus in bello. Whether or not you're fighting in self-defense, or whether a UN Security Council resolution applies, that's the jus ad bellum. So it's two different types of law. They often intersect, but what we really say is that they're different. So even if a war is a violation of the jus ad bellum, so one side is, for instance, the aggressor, that means nothing for the applicability of the jus in bello on both parties. So even if you're the victim of aggressive use of force, you still need to adhere to the laws of armed conflict, the jus in bello, the international humanitarian law. And when we look at international criminal law, so that's the part of international law where we criminalize and where we prosecute individuals. So that's the International Criminal Court, for instance, and the tribunals, Yugoslav Tribunal, Rwanda Tribunal. If we look at international criminal law, we're looking at the crime of aggression when we talk about use of force, and we talk about war crimes when we talk about violations of international humanitarian law. Basics. What is the use of force doctrine? So that's we start with the left, then we go to the right. What is that, the use of force doctrine? Well, pretty much, and this is like a bunch of states, United Nations, after the First and the Second World Wars, they agreed no more. They created the United Nations to prevent future generations from the scourge of war. That happened twice in our lifetime, the preamble of the United Nations says. And they pretty much said, first and foremost, what we no longer want is that, and therefore the prohibition to use force is the key rule. It's in Article 2, Paragraph 4. Unless two exceptions, authorized by a United Nations Security Council or in self-defense. And particularly self-defense raises lots of gray areas, because what is really self-defense? And we don't always know exactly, because international law is also characterized by very little case law. Very little descriptions, judgments coming out of tribunals, courts. Because usually, to ask a court to rule on something requires both parties to consent to. And that doesn't happen so often when we talk about use of force. So the international courts don't often get a say, get an attempt to actually crystallize these kinds of doctrines. And so use of force, self-defense, so when it's lawful to use force in response to someone else's aggression, someone else's use of force, What we do know about is that it's only allowed when it rises to a level of an armed attack. So not with border skirmishes, not with just a military person stepping on the other side of the border, because a military person is use of force. If they step over the border, it's use of force. It is use of force. It's prohibited. But it's not enough to qualify as an armed attack. It's not enough that the other state may say, we can fight back in self-defense. We don't want to escalate. So it needs to have the level of severity of an armed attack attributed to another state, according to the International Court of Justice in the armed activities case, before you can respond and say, I invoke the right to self-defense. And then there's always the question of humanitarian intervention and responsibility to protect. Isn't that a third exception to the prohibition to use force? Well, that's complicated, but the short answer is no, it's never arisen to that. There are humanitarian interventions where, for instance, Kosovo, 1999, when NATO used force against Serbia because of the ethnic cleansing of the Albanians. And there was a report, a commission of established international law scholars, and they said, it's illegal. They also said, but it's legitimate, in the sense that we understand there's a bit of a gray zone. It wouldn't quickly be seen as aggression by some, by others it is. We don't really know. But it's definitely not acknowledged without approval, authorization of the Security Council. It is not just lawful. But that's not the topic of today, although, of course, Russia pretty much claimed humanitarian intervention when it invaded Ukraine, because it needed to protect those Ukrainians against the genocide that was being committed against them by their authorities, which, of course, isn't true. The use of force doctrine. So Russia's invasion of Ukraine is a real clear-cut example of aggression. We haven't seen such a clear-cut example for a long time, and we see it now, unfortunately, every single day. 2014, Crimea occupation is also an aggression, an act of aggression. And also the attacks in 2008 on Georgia, also aggression. So the rule being also no territory may be acquisitioned from illegal use of force or third-party interference. So this is the basics of use of force doctrine. If you annex, so Crimea, according to international law, there is no way that it would be allowed unless Ukraine submits to that, but there is really no way that other states could lawfully force Ukraine to sign off on Crimea, since that is a direct violation of law, of what the UN General Assembly has said. That should never be possible, because if it's possible, then states will do it. And that, of course, is what Russia is trying. That, of course, it's a more complicated picture, I very much understand. But when we talk about law, then this is not allowed. And this also goes with third-party interference. So there is a difference when use of force, when a part of a territory secedes without any support from outside states, but themselves declare themselves independent, or whether a third state is there with force present. So these are some of the basic aspects of use of force. Now, if we look at Kursk and Western weapons, I get a lot of questions. Yeah, but now that Ukraine is using force in Russia, now that we are, the Western weapons are being used in Russian territory, isn't that then also a crime of aggression, an act of aggression by Ukraine? Or by us, by allowing our weapons to be used there? Well, that's the answer. The reason is that once you are under that attack, once it's that you are the victim of aggression and you have the right to self-defense, you can fight off that aggression. And that doesn't limit just being there and trying not to be hit. You are able to then fight back, but proportionate. What that exactly is, we don't really know. Does that mean that you can go all the way to Moscow to regime change? You know, if you think logically, it's Putin that is the aggressor. Like, it's never going to stop until Putin stops. We need to go to Moscow. We need to change the regime. I don't think that a lot of international lawyers easily will say, sure, that's fine. I think a lot of us will say, that's probably taking it too far. But we also don't really know because we do not have crystallized law in it. What definitely is no doubt allowed is what Ukraine is doing in Kursk. So trying to fight off, as long as you, but that's IHL that we're going to, as long as you fight in accordance with international humanitarian law, if you're trying to fight where the missiles are being fired from, that is allowed. You're also allowed to receive support, and every other state in the United Nations is allowed to give support, to give weapons, to go there with the military themselves, to invade Russia, because it's all self-defense. That's what we call collective self-defense. So if a state, not if a state doesn't ask for it, but if a state says, please, United Nations, I am under attack, I'm under an aggression, I want to invoke the doctrine of collective self-defense, any other state is allowed to fight. You could actually say every other state is morally and maybe even legally obliged to fight, because this is what the United Nations was established for. So, in that sense, that wasn't so complicated. But now it becomes more complicated. Iran strikes on Israel. So what we see here is, I think of last night, I saw it this morning, the Iron Dome fighting off Iranian missiles over Ashkelon. Iran is saying it's retaliation for Israel's assassination of Hamas leader Haniyeh in Tehran and for Hezbollah leader Nasrallah in Beirut. Retaliation is a new word, and we see it every day now. So, is retaliation lawful? No. So retaliation, punishment, or anything like that is not one of the exceptions of the use of force. Only self-defense is, well, and the Security Council authorization, but of course there's no question to it. But is it self-defense? So the retaliation, you know, the saying, we are retaliating, we're punishing, we're fighting back, etc., that is not a legal concept that would be allowed. But isn't it self-defense? Because Israel attacked the Iranian embassy in Syria, they were fighting in Iran itself. It becomes more complicated because, Israel, of course, also is saying we are fighting in self-defense because we're under constant missiles from Lebanon. We're on constant attacks, and Iran is financing and supporting that from everywhere. So here we see it becomes much more difficult to establish who is it an aggression? By who is it aggression? Is it therefore really self-defense? Or are we seeing all sorts of violations of the use of force? And in principle, we all think, international lawyers, or most of us at least, think definitely what we're seeing is a lot of violations of the use of force. Not necessarily that there is one party that isn't violating this use of force. Now, the rule for self-defense is that the response needs to be immediate to repel the armed attack. So, arguments that it was, because Israel attacked the Iranian embassy, long time ago, months ago, weeks ago, or Iran itself, is not immediate. That is not immediately trying to respond to try to stop the immediate danger. So therefore, self-defense doesn't apply. Another thing is preventive self-defense. You know that they're making missiles. You know that at some point, they would want to, etc. that's not allowed. Preemptive self-defense is, where is the divide, you know? So you do not, if the missiles are pointing at you, you know, you have intelligence, they're going to shoot, then we're talking about preemptive self-defense, and it's allowed. When it's, yeah, but you know they're going to build those missiles, or you know at some point they're going to move it there, then it's not allowed. Where is the dividing line? We don't really know. It's difficult. But those are sort of the categories that we have to work with. So then, more news, unfortunately. Israeli airstrike on a village in Lebanon. The pager attack we see in below left, and the tanks moving to the Lebanese border. And we have seen the last couple of days that there were ground forces in Lebanon as well, across the border. So then the first question, because we're still talking about use of force, and we're going to talk about international humanitarian law shortly, but when we talk about use of force, we need to ask, if you're bombing Lebanon, if you're using ground troops, was there then an armed attack on Israel? And the International Court of Justice has said it needs to be attributable to another state. Is it attributable to Lebanon what Hezbollah does? I'm not an expert on Lebanon. I find it complicated. I think the response of Lebanon has been difficult, complicated. So again, and then if you are under attack of missiles, I don't think international law gives so much guidance here, other than, I think, gut feeling, probably none of it is allowed, as what I said. And therefore, I think it's more important to think about who will stop rather than who has the right to use force. I think the real essence, the rationale behind all of this law is to say, you shouldn't. Remember, when the United Nations was created, it was to prohibit use of force unless you really had no other way to respond. When you're really under armed attack and there was no other way, but to really try to fend off that attack, that immediate attack. And so I think what we need to do is talk less about who might have that right to self-defense, but more about who is going to stop this cycle of violence, and not to escalate by fighting so that you think it can be de-escalated, which all sides, of course, do. Not the people, but the fighters. And what we see now is a very clearly, so even though the use of force has some difficulties and gray zones, and we don't always know, there's just so little, there's a lot of gray as well. What we do see very clearly is an epidemic of international humanitarian law, the laws of armed conflict, violations, with exceptionally high human suffering, and a seemingly complete disregard for compassion, for empathy, and for law. The last one, of course, my profession, but yeah, to see all of those humans suffering, and I think you're all here for that same reason. Is that what we're supposed to be doing? Is that why we designed law? And so also with the pagers attack, just an example. Was that lawful? I hear a lot of experts in the media rejoicing, saying, wow, that's so clever. You know, like so many people, so many lawful military targets, so many lawful fighters. People, therefore, are, when a fighter, when it's military, they are lawful military targets. And so many of them were killed, and I can understand that that's a success. But so many other people died. And that is the reason why it wasn't lawful. And there's two reasons for that. One is that the type of weapon, this pager, and these types of devices, are devices that you don't see that would be dangerous. You think they're harmless. And when they explode, a normal human object that you use, when that is used as a bomb, we call that a booby trap. And a booby trap is mostly outlawed, and it is outlawed by the law that Israel has signed. I'll spare you the amended protocol of the Conventional Weapons Treaty, but that is one reason. The other is, and that's with IHL that we're going to, the other problem with the pagers is that when there's thousands of these being sent out, you don't know, you don't have control over where all of them are going. So even though the booby trap isn't allowed in and of itself in this situation because Israel has outlawed them, but if you do one of those attacks, then you might be super sure who that person is that has it, and if that's a lawful target, then you've killed your lawful target. But the problem with so many of these booby traps is that you don't know where a lot of these come. And not all Hezbollah members are actually lawful targets. A lot of them are not active fighters. But of course, there's also people that were carrying that weren't Hezbollah members, were children, for instance, which is also one of the core aspects of international humanitarian law that we're going to turn to now. So what is it? The ICRC is the International Committee of the Red Cross, or the Red Crescent. They explain, international humanitarian law is a set of rules that seeks for humanitarian reasons to limit the effects of armed conflict. It protects persons who are not or no longer directly or actively participating in hostilities and poses limits on the means and methods of warfare. It's also known as the law of war or the law of armed conflict. Now, the basics are the following. So killing is lawful. When people say you can't do anything in war, that's not true. You can actually do a whole lot. But there are some basic rules. And a very important one is the principle of distinction. It's the core of international humanitarian law. It tells fighters that they can fight against other fighters, combatants, and they should not fight against civilians. They should not cause additional. A war is already harmful for civilians when they live there or they have to flee, but they shouldn't do anything that causes extra harm, additional harm. They should do everything possible to make sure that civilians that are not part of this war are also targeted. And that doesn't have to be so difficult. And sometimes it really is difficult. And then the law says, then you cannot. The law doesn't say, oh, well, we tried, so we do it anyway because we couldn't. That is not how it works. So the principle of distinction, to distinguish between a military target and civilians and civilian infrastructure, but also an assessment of what is the military advantage of an attack. So when you're attacking just civilians, you can't. It's a war crime. So any attack that's just purely people, and there's no military advantage other than that you think that military advantage means, which it doesn't mean killing people, killing the enemy in that sense, that is exactly what is the core of all prohibitions. But if it's a military target, so a military basis, of course, is the easiest one to imagine, then you still need to do an assessment. What is the military advantage? Well, a military base is quite clear, but also if there's other types of targets, what is the military advantage? Is it necessary? And that means, are there other means to do this without using the force, or with using fewer force, lesser, fewer, one of the things. And then, in addition, a proportionality test. If there are civilians around that could be harmed, well, first of all, necessity again. Could we do it in a different way that doesn't have that civilian harm to civilians or their infrastructure? But also proportionality in the sense that if the civilian harm or collateral damage, in a really dirty term, if that is larger than the military advantage, And here, of course, you're all like, whose assessment is this? Because you can, of course, like really differ on how to weigh what's important and what is crucial and so forth. But here comes the very famous proportionality test. How does it weigh against each other? And even if you think, we still can do this, then still you need to do everything possible that is reasonably possible to take precautionary measures. And what we also hear a lot about is warnings, for instance. Warnings is one of those things that are precautionary measures. So there can be the obligation, so there could be, okay, the decision, the military advantage is this, the civilian harm is this, there will be some civilian harm, but the military advantage is so massive, we're still going to do it. Then still, you are obliged to try and warn people to go away, that they can flee. It's still all human life matters, and it should matter. And then what often is misunderstood is that they say, well, if you just, do like a warning shot, then they know. And then if they don't leave, then you can attack. But the thing is, it needs to be possible for people to go away. So if you're attacking a hospital, and I'll come back to the special status of a hospital. If you're attacking a hospital and you say, yeah, but we warned, but you're lying there in a hospital bed on an IV and you cannot leave, or there is no other hospital anymore, that doesn't mean we've done our precautionary measures. It means it's not possible for people to go away, and then we go back into the no, then it's not allowed. Those are the basics of how we look at international humanitarian law. And another misconception that you often hear is that as soon as a few fighters are hiding among civilians, that then suddenly it's allowed because it becomes a military target. Well, at some point it does, but a few and many, and how much is that? The International Court International Criminal Tribunal for the former Yugoslavia, the ICTY, has done quite a few rulings on this, judgments for the Yugoslav war. And they have pretty strict case law where they say no. If civilians are suffering, if there's a few fighters that are hiding out among the civilians, it doesn't suddenly become a lawful target. You still need to protect that civilian population. It does recognize that at some point it becomes different. But the interpretation that the International Criminal Tribunals give to this is not the same as we often hear in the media. And so that is something to consider. So the assessment, and this is where it becomes really, really problematic and difficult, also when we hear experts say, in the media, is, for a specific attack, when there's one attack, and then all the media, they all ask, and everyone, was this a war crime? And the problem with, one specific situation of, an attack is that you don't know for that individual situation what the intelligence was. What was their actual knowledge at that point of what that military advantage would be? And what was their knowledge at that point of what the civilian suffering would be? So it's not on the basis of what actually happened, but on the basis of the knowledge that they had back then, and we don't know that. We don't have the intelligence they have. And so at that moment, when people ask us, international lawyers, at max we can say, it appears, maybe, it looks like, but we don't know. And so what you hear after all of these attacks is international lawyers saying, we don't know. And then the media says, international lawyers disagree, or they don't know, so probably it isn't, or you can look at it all those sorts of ways. But the essence is, we don't know because we don't know what they know and knew, and only then can you really know. Do you know what I mean? Do you understand what I'm trying to say? And so that's difficult. That's why you hear a lot of and yeah, maybe, and it appears from us. But I have no trouble saying that if we look at the wars, for instance, Russia, Ukraine, and Israel, Gaza, that if you look at all of those attacks where so many civilians have been killed, I don't believe that there is not a whole lot of IHL violations among them. And surely there'll be, some of those attacks that may be looking like a war crime. There's actually a good explanation for it. And we don't always know which one. But there are quite a lot. No, there are very many disturbing situations that we've been seeing every day that I don't believe that all of them have that justification. So, for instance, obviously, very clearly, the 7 October Hamas attacks, well, they don't even try to say that they saw a military advantage. They did. Definitely 100% nothing in IHL that would justify it. And I understand that a lot of people will say, yes, but, look at all of those years of occupation. I'll come back to the occupation. Whatever Hamas did on 7 October has no justification. No matter how bad anything is, there is nothing that will justify that kind of force. But that also goes for attacks on residential areas. And there are too many examples, or attacks on civilian infrastructure, or for instance, that theater in Mariupol, or what I just said, those pager attacks in Lebanon, or attacking fleeing people, or people that are trying to get humanitarian aid. And hospitals. Hospitals, we have seen so many hospitals being attacked. We almost forget that hospitals were the one buildings that we always say is an absolute no-go, really, like the most strongly protected building in international humanitarian law. The hospitals are attacked one after the other. And they are protected for a reason, because they have life-saving functions. They care for the wounded and the sick, and the wounded and the sick are not lawful targets, ever. Now, what is true of this story? Because what you often hear is, well, there were some, for instance, Hamas fighters in hospital, or Ukrainian fighters in a hospital, so they lost their protection and therefore we could attack. Well, what international humanitarian law says is, yes, they lose their special protection then, and then with how many fighters? Definitely not with one or a few fighters. That's not enough to lose the special protection. But if there's a proper command center there, you can argue that it's become a military command post. So then it can lose, indeed, its protected status, but it's still a civilian infrastructure. So the extra protection may fall away, but not the protection as a civilian infrastructure. So there we go back to the original assessment. What is the actual military advantage compared to the civilian destruction? And not just, all the humans that are there that can't go anywhere, but also the fact that there's so many other hospitals already fought off, and there's so many people that are being attacked and therefore need a hospital. All of that needs to be weighed in to that assessment of whether that not only loses its special protection as a hospital, but also becomes a lawful military object. And to be fair, I don't see any, maybe only in theory, but I don't really see any feasible situation where the military advantage and the necessity and the proportionality, and then, of course, what you're able to do in terms of preventive measures, where that would weigh up, that you can just start bombing a hospital. But that's what we see. Also, dressing up as health workers is also a violation, perfidy, also a violation of international humanitarian law. And what we saw a couple of days ago, a double tap strike, that's like the lowest, That's what happens then is you attack, in this case, again, a hospital, you kill, other people come to rescue, to help, and then you attack again. You attack the people that are helping. But we're seeing it every day. So humanitarian aid, so where I talked about when attacks, where it can be complicated because we don't know the intelligence, With humanitarian aid, it's not complicated. IHL requires states to allow and facilitate humanitarian relief, rapid and unimpeded passage. It includes drinking water, food, electricity, and fuel. And we see this, of course, particularly, but we see it in many conflicts, and I think, and I'll come back to that, I think that that will be a big part of a case or one of the cases that the International Criminal Court will take up if they dare to do so. If they dare to take up cases, I think that will be the case. Because it happens in so many other conflicts where the International Criminal Court does not have jurisdiction. And what we also, and so irrelevant that it's in response to any other crimes, there is no justification. I said that before, like there's no way that that can then become okay. It's also not true that this international humanitarian law only would be violated if it's a full blockade. It says any blockade. And it's, of course, really vulnerable people that are under attack when you attack humanitarian aid. And again, said it before, it's not that I don't understand, at least I do understand that you can think in an all-out war that you need to do everything to stop the violence. I just don't think, well, the law also doesn't think, but I also don't think that this kind of violence actually helps bring down the violence in the long term. So, if humanitarian aid is hampered intentionally as a weapon of war, that also amounts to a war crime. It could also be a crime against humanity, and it could be a method of genocide. Now, I've said a lot of no's, so a lot of violations of international law, and therefore, the question, of course, is why is international law not enforced? Well, most particularly, this is because of political will. International law doesn't really have those teeth. International law doesn't have a military of its own or a police force, so it really requires states to cooperate, states to enforce that international law. Without it, without states' willingness to enforce and to compel other states to comply, international law is a language. And I'm not saying that international law as a language is powerless. It just doesn't really have that might that a sword could have. So what can international law then do? It can provide that language to help distinguish right from wrong and fight disinformation. I'll come back to that later. And courts can issue judgments that states should enforce, and history books can narrate for future generations. What we have is a bunch of courts, but two of them here in the Netherlands, in The Hague, are busier than ever, and the most important ones when we talk about war and law in war. So that's the International Court of Justice in the Peace Palace in The Hague, and the International Criminal Court. And this is how they look on the inside. And you would say, and the International Court of Justice on your left is the Court of the United Nations, and it was established together with the United Nations in 1945, even though it had also a predecessor before that, the League of Nations. And their judgments should guide the world. And for instance, one of the things that I think makes it so complicated in the discussions on Israel and Gaza is that we don't really know how, or people disagree how to think about that age-old question of the legality of the occupation of the Palestinian territory. And the International Court of Justice has said a few things, but first, the law of occupation is also part of international humanitarian law, IHL. Is occupation ever lawful? Well, it can be under the rules of the law of occupation. And so the question we come to then is the presence of Israel in the occupied Palestinian territory lawful? Well, first, the ICRC, so this is the Red Cross again on occupation. It can be, to preserve the status quo ante, and when it's temporary, and it aims to ensure, the occupation aims to ensure the protection and the welfare of the civilians living in the occupied territories. And of course, it's much more complicated, but those are a few key elements. And if you want to read more on the law of occupation, the website of the ICRC is a magnificent source. It really explains the rules of international humanitarian law in a very accessible manner. So, because of course this conflict for a long time has been really complicated for international lawyers to answer, and politicians and people, the humans that live there in Israel and in the Palestinian territories and around, the United Nations General Assembly has requested an advisory opinion to the International Court of Justice in December 2022. And it asked these questions. Pretty much, what's the legal status and what does that mean for other states? And the advisory opinion came this summer, 19 July 2024. And it was hoped that this would guide parties to at least find, this is what I really had hoped, and still hope at some point, maybe with, on all sides, new generation of leaders. But that it could be something that everyone that is now suffering in this conflict, be something to unite over. Apparently, this is the legal opinion of the World Court. Maybe that can be a way to draw a line. So, the advisory opinion says that the continued presence of Israel is unlawful and that it needs to come to an end. And that Israel is under an obligation to cease immediately all new settlement activities. And a few other things. We have that judgment or opinion. And then we also see South Africa versus Israel, a case where South Africa brought a case to the International Court of Justice under the Genocide Convention, which of course is terrible for the people of Israel to experience. The ones for whom pretty much the genocide term was coined by Lemkin because of the horror that was done to the Jewish people, and that they now are in this court having to answer to South Africa and a number of other states that say what you're doing now in Gaza actually also meets the criteria of the Genocide Convention. I think everyone can feel that that's a really painful situation. But this is where we are. And so far, the court has concluded that it's plausible that Israel's actions in the Gaza Strip could amount to genocide and issued provisional measures. Now, what's important is that the International Court of Justice has not said there is genocide. We are in a provisional stage, which means that the question on the merits, whether or not it is genocide, or whether or not there is incitement to genocide, or whether or not there's a violation to prevent genocide, it's a lighter version of that will come later. That will take years to answer. What South Africa now asks for is a provisional measures. And in order to give provisional measures, first the court needed to assess whether it's at least a plausible claim. So that is a word to say it's not completely ridiculous. It's possible. And that is what the court said. So it didn't say there is genocide. It also didn't say no way there's genocide. It's plausible. And that, in and of itself, is huge. Because when it's plausible, it means that there's a risk that if you are supporting with weapons, that there's a risk that there could be genocide and that that could aid. I saw a hand. Yes. The crime of genocide, and that's in the Convention of Genocide, means that it's an attack on a protected group on the basis of nationality, ethnicity, race, or, oh good Lord, religion, sorry? Oh good Lord. The Lord told me. And that attack is with, and this is where what differs genocide from the other crimes, where that attack is with a specific intent, specific intention to destroy that group. So there's also attacks that are directed at groups, but not to destroy them, but for instance to make them leave, or to punish, or to stop an attack, something like that. All of that, those can be crimes against humanity, but the term genocide is reserved for those situations where those that are doing the attack really want those people, well, usually they don't think of those as people anymore, to be destroyed, in part or in whole. So it doesn't need to be the entire people, it can be part of that people, and it can also be that with that intent, one or a few people die, even though the intent was for the larger. So it doesn't actually have to be a real mass killing for it to be genocide, but that specific intent is crucial, and it's also really difficult to prove. It's really difficult, and so there is the possibility what then happens, because the Nazis were, they wrote it down, but since then people tend to not write these things down, even if they would be thinking, which we then don't know. So what we do in trying to prove it is with circumstantial evidence. So we look at speeches, for instance, or other types of acts, and that you, with the whole of the acts and speeches, as well as trying to understand what people may have derived from that, whether that paints a picture that meets that criminal law standard of beyond a reasonable doubt. So it's a high standard, but not exclusively based on whether someone has said, I have the intent to destroy. I feel like it's thrown around a lot. Yes, it's thrown around a lot. Yeah. It's thrown around a lot, but legally, it's thrown around a lot for multiple reasons. For instance, when every mass killing is seen often by the people that are experiencing it as a genocide, and I completely can understand that. But if it's not with that specific intent, it isn't. On the other hand, something can have that specific intent, and it doesn't need to be as bad as the Holocaust to still be able to meet those standards. It's a different assessment in law than it is in the normal vernacular, I think. Thank you for asking. That's a very good question. So what the court has not been able to do, or not done, is to impose the provisional order to seize all military activity. It's done that for Rafah, and for that area, because that was at the moment also where it looked as if Rafah would be closed, and that would really create a very dangerous situation, the court considered. But what's important to realize is that the International Court of Justice only can give provisional orders when they're really related to the Genocide Convention. It's not a case on their use of force. It's a case on whether or not genocide is occurring or genocide is not prevented. And therefore to say you need to stop and seize all military measures, military force, is a step too far from that Genocide Convention. Probably for those that aren't lawyers, you're like, you guys are crazy, but come study law, and then we can talk about a whole lot. Yeah. So, since, we have the World Court that said a few things, at very least it said, we are very worried. Please think about the human suffering. And it says that to everyone, of course. But that has not been happening. And we see Gaza being increasingly destroyed, we also see human suffering, of course, in Israel, and we see human suffering now also in Lebanon. There's also the International Criminal Court investigation of the state of Palestine, and I'll spare you the legal issues on jurisdiction, or not if you want to ask me in the Q&A. But they have now come to applications for arrest warrants, 2 sets, both for Hamas leaders. Not all of them are alive anymore. We know that Hania has died. Dave, I don't think we know, since it's claimed both ways, and Sinwar, I think, is alive. And then there's also applications for warrants of arrest for Netanyahu and Gallant. The ICC has not yet come with the arrest warrants, and it's still pending, and the international law community doesn't understand what's going on. So in theory, there could be a sealed arrest warrant. I think more likely is that the ICC judges find this a really difficult situation. So we are waiting and seeing what happens there. And I said this before, if there's going to be cases, well, I think the Hamas cases are really clear. Huge human suffering in their attacks on 7 October in particular, as well as continued attacks on Israeli civilian population since. But I think a very interesting one to watch is what the ICC is going to do about the prevention of aid, humanitarian aid. Because already on 29 October, Karim Khan was standing at the border in, I think it was Rafah, saying, preventing aid may be a crime under ICC jurisdiction, so already indicating his concern. In Ukraine, we also see an ICC investigation. There are now 6 arrest warrants that have been issued by the pre-trial chamber, PTC, particularly related to children, the children abductions that are being put in rehabilitation centers, I think they call them, brainwashed and then put for adoption, or I heard, I don't know whether that's true, but put in the military to fight against Ukraine. So Vladimir Putin and Maria Lvova-Belova are definitely being prosecuted for those crimes related to children, and the other are particularly prosecuted for civilian harm with their violations of the principle of distinction and attacking civilians. Now, coming towards an end. Obviously, law doesn't bring peace when states continue to violate it, and when other states do not compel states to comply with law. And how about justice? We don't see that much, right? I think it does depend sort of on the long term, perhaps on what you understand justice to be. And I think one of the problems with talking about justice is that people understand justice and therefore the success of international criminal law or international law only in terms of whether people go to jail, whether they see the inside of a prison. I do think that law can do more than that. And I'm not saying, ooh, therefore law is amazing. By the way, I don't think that law nor is politics necessarily a vehicle of the good, or politics only a vehicle of the bad. It really depends what you do with law, whether that applies in a good way or in a bad way. And law always needs to be understood, I think, particularly international law as well, as a vehicle that tries to defend the status quo, that mobilizes the injustices that the status quo is based on. That doesn't mean it's all bad, but to understand law also requires you to understand how law is being produced and what it then can continue to produce. But what we can try to do is make that better, step by step. So that goes to a false dichotomy that we often see when we talk and answer the question and discuss and dispute, and I'm sure that you all do that as well in the bars, student bars, or at other occasions. What's the point of a law? Or you don't even talk about it anymore, probably. It's not even interesting anymore. What is the point? So in my research, what I think is really important is that we understand that discussion as a false dichotomy between legalists and realists. Legalists saying, law, you need to, if everyone complies with law, we would have peace, we would have justice, we would all be happy. International law, international criminal law, it all brings good things, and it can do great things if only everyone would just comply. Look at what it can achieve. Part of it is, of course, true. Part of it is very idealistic. But the realists are always saying, look at all that destruction, and there are these judgments. Obviously, there is no point to law. Law is dead. If international law is dead, if it had ever existed, and they probably say it hasn't ever existed. We see every day with the violations of international law that law doesn't exist. So, but then there, I think they misunderstand, they oversimplify that international law has become the dominant vernacular in politics. When we talk about war, we talk in the language of law. And when everyone is talking in the language of international law, why would they do that? Would they do that because it's nothing, it's irrelevant? They do that because it's become a language with which to persuade that you're on the good side, or that they are on the bad side. It carries power, therefore. It's maybe not the power to put people in jail, but then what is that power? It's much more complex. But always, as I said, be aware that it's also reinforcing injustices, or can be. So aspects of the power that law does have, what it does give, to at least end with a few things that it is positive, because I feel like I've made you all depressed. And maybe that's because when I woke up and I looked at the news and I saw those attacks, I was pretty much depressed, and I was like, what do I talk about tonight, you know? But I do actually really think that it's, you know, overall, there's some really important things that law can do that without it, we don't have. It is better than nothing, and I don't mean to diminish that too a little bit. It gives us a language to look at politicized conflicts with rules that are applicable to all. I know many of my colleagues, international lawyers, and I have the same. I don't care which nationality or which side anyone is fighting off. When you're attacking civilians, you are a war criminal. I don't care about the rest of it. I care about the legal aspects. Of course I care about the politics. Of course I care about the facts. But international law does give us a language to try and go away from all the historical connotations, which can be very relevant for the assessment of law, but at least in a way that you ideally try to avoid being too partial on one side or the other. For me, all leaders that are committing that kind of violence, where so many innocent people suffer, they all should be prosecuted, not one side or the other. That's the way I look at it, and I know that many of us lawyers do that. And maybe that's, you know, maybe something happens to us in law school. That's also why a lot of people don't like us, but lawyers. Maybe, I don't know. But we find that also in a way, yeah, I don't know, more neutralized or something. Even though it's, you know. What it does also give is that it gives a structure to investigate and to verify and analyze evidence, facts, what is actually happening, not what do you hope is happening or what do you hope isn't happening, what is actually the evidence, what kind of weapons are used, against whom, and so forth, and with that language of law to analyze what has happened and what is lawful and unlawful about that. It gives you forums, courts, where people can argue on how the law should be interpreted. It creates and sets norms and enforces them, develops them as well, and it gives a language in which to communicate to the world what is right and wrong. But it's also, and I think this is one of the most important aspects what law can give, is that it acknowledges victims, at least that what they're saying is heard. When, for instance, the MH17 case was decided in the Dutch criminal court in The Hague, and the court said, we acknowledge we have the evidence here is the proof that Russia since 2014 had indeed been fighting on the territory of Ukraine. What Ukraine had been saying for years. They said, world, Russia is fighting on our territory. It's committing aggression. But no one wanted to see. And when that judgment came out, at least, for Ukrainians, it was, you see? And now it's at least on paper. And it will therefore be in the history books, and otherwise it would not. So it is something, it's definitely not helping Ukrainians. Look at where they are in a real materialistic sense. But there is something about acknowledgement that is better than not acknowledging. Fighting disinformation now and in future history books. What I'll skip, but only mention really shortly, yesterday, for instance, there was one of these positive developments. A year ago, I drafted with some co-authors, Belarusian lawyers, opposition, a big report on crimes against humanity that President Lukashenko is committing since May 2020 in the post-election, pre- and post-election violence. And yesterday, Lithuania decided, or of course they decided it before, but yesterday they went to the International Criminal Court and they referred the situation to the International Criminal Court. And now it will be on the website of the International Criminal Court. There will be that acknowledgement for the Belarusians, and maybe, hopefully, more. Maybe, hopefully, that will help break down the power shield around Lukashenko. Maybe more and more will think, if we keep on supporting Lukashenko, we actually might end up in jail. Our assets will be frozen. We cannot travel to the 124 countries of the International Criminal Court. That are the aspects that can be helpful. It helps create sanctions. It helps hopefully crumble the power insulation around dictators. So then, law is most certainly not perfect and not a guarantor of peace and justice. But it's what we have and what we need to improve, and hopefully you, next generation, or the current generation, but hopefully we can do better. And also, it's what states should want to uphold rather than try to destroy. They created it for a reason, all of them did. Towards a world that will never be perfectly just, but that can be so much better than this. And I hope with empathy, compassion, and limiting human suffering, and trying genuinely to fight for peace and justice. That is what I had to say.
Thank you, Marieke, for this crash course through a very difficult topic. You said before we could talk for hours. We have around 20 minutes to do questions. I'm going to go straight to the audience. My colleague is walking around with a microphone, so raise your hand if you have a question. We'll start here, 1, 2, and then we'll continue.
I had a question about the self-defense topic, because you said self-defense needs to be immediate, but how does that take in account for mobilizing troops? Because that can also take a few days.
True. So it's all, and that is, I started with that. There's a lot of simplifications in this because it's a crash course and not a full master's program. So a lot of what law is, also other types of law, is about reasonableness. And so it is about responding, but definitely with mobilizing, that can take not just days, can take more. That is fine. It's just that you cannot say, oh, last year you did this, so now I'm going to do that. Is that an answer to your question?
I saw another question there, and then one here.
Well, thank you for the lecture, and you primarily took a law perspective, but do you think that it's also possible to take a perspective from international relations to better enable enforcement of international law with, for example, the theory of polarity?
Do you want to expand on this?
Yeah, so polarity is explaining international relations in terms of power, influence, in terms of economic size, diplomatic influence and military capacity.
And what exactly is your point and question?
So the countries that have bigger powers, they are also the actors who are able to enforce international law because they have the power in the world.
Yeah, well, that's what I tried to say. Like international law, like it gives us something, but to actually enforce, we need states. And powerful states can do different things than smaller states. But I think what you also can see is that also some of the smaller states can have actually really important influence. What we also see is that, for instance, also the Gambia has brought a case against Myanmar for the International Court of Justice, and also all sorts of things. But to actually force and create sanctions is something that would be very helpful if powerful states would do that. And instead, what we see now is that a lot of the powerful states, and I'm also talking about China, and I'm talking about Russia, I'm talking about the US, but also the UK and France, they're actively forcing small states not to do this or not to do that, to at least to follow their lines, with repercussions as a consequence if they don't follow their line. So it would be great, and I think that's, the only way where international law can have a better point in war, if states do something about it.
I saw some hands over here. Yeah, one there, and we'll continue up.
Hi. Since there are different countries have different laws, what laws and punishments apply to war criminals? Does it depend on the region, or do they have different and agreed upon terms? Like, is death penalty on the table for them, or is it just prison, and whose prison, for example?
That's a great question. So international criminal law, for instance, is enforced not just at the international criminal tribunals, where then the tribunal has a set of laws that is negotiated by the international community. Those are multilateral treaties often. But international criminal law is also enforced in domestic courts. And there, in domestic courts, such as in the Netherlands, but also in other countries, there you see variations. Very often, most countries now take for instance, the rules of the International Criminal Court as sort of a basis for these types of rules that they then would prosecute. But yeah, a country like Iraq, for instance, has the death penalty. And when they prosecute in accordance with their domestic law, then there's not a lot that other countries, they might say, like, we don't agree with the death penalty. Actually, with Iraq, there was a big sort of issue with UNITAD. That's like an evidence mechanism that was created to support the Iraq system with prosecuting Daesh fighters, ISIL fighters. But then because the international community had assumed that Iraq would abolish the death penalty because they sort of said, yeah, we can talk about it, and then they didn't. And then the UNITAD wasn't allowed by the international community to share the information they were gathering with Iraq. So sitting on a pile of information and that not really working. So they then have shared a lot of information with other states, but yeah, there is, of course, states that are sovereign and have their own rules. They're not necessarily bad rules if they're different rules, and if there are rules that others don't agree with, then they tend not to cooperate bilaterally, and then there's all sorts of politics involved. Does that answer your question?
It's difficult, as with many situations, again. We have a question there and a question there. Lenya, there and then one up.
I had a question about how we've seen the international rules-based order in the world essentially crumble over the past few decades. And kind of adjacent to the question that was asked before, we live in a world in which a lot of previous power structures are changing, and the influence spheres for large players in the world are becoming we're kind of gaining a lot of different regions in the world that are able to be big players in these cases and also hold veto power, for example, in the Security Council and stuff like that. And what I heard you say in this speech, which was really enlightening, but most of the focus was what the status quo is. And I'm wondering international law and all of these international systems aspired to be more than just a tool for historians to explain what happened. So I'm wondering, is there in your field of work or within like the community you work in or internationally any efforts to reform the system, to actually take away, for example, some of the roadblocks, veto powers, reform institutions, to actually make international law and international institutions live up to their stated ideals? Because if we don't, then we're essentially overpromising civilians in the world and causing a lot of disillusionment and leading to situations in which civilians just look at this and think, what's the point?
So lots of yeses to everything you said. Yes, we are overpromising because, and I don't want to overpromise. That's why I don't think that international law can break through those blocks of politics as it stands. But I do think that still it is important to point it out, to acknowledge victims and these things and so forth. But in order to move forward with this project that is so heavily destroyed by big powers, as you explain, we would need indeed that change. And we know that those vetoing powers are also vetoing these kinds of changes, and it's been really difficult. But there is more and more energy in the General Assembly. It started in 1950 for the Uniting for Peace resolution, and now it's invoked with an idea that the General Assembly then can say, when the Security Council is blocked, we will decide on a matter of peace and justice, which should have been, or at least that's what argued, kind of was, only the prerogative of the Security Council. So you do see that the General Assembly is taking a little bit of a different role more and more, and I think that is where we can see some changes. And you also see that also on the Israel situation, more and more is decided, or at least discussed there. But the General Assembly doesn't really have the binding powers, but then again, the Security Council does, and does that matter much? So I do think it is more about trying to come together and try to come with, solutions, coming together, compelling others to comply, speaking the word of progress again, what you said, and the coming together and the being the United Nations, saying there was a reason. This exact spiraling out of control that we're seeing now today was the reason why the United Nations was established. And now we're here, back again, and everyone's saying exactly, what's the point of it? So we are at a huge risk to, I think, destroy it all. But we don't have to. It depends, I think what we are envisioning with reform is taking away the veto power. I think that will be difficult, but I have seen some, here and there, like a couple of weeks ago, like maybe there should be more people, like states in the Security Council. So maybe I think we need a new solution rather than asking veto powers to give away their veto. Like that would be ideal, but everyone's been asking for 50 years and they're not doing so. What then are other ways to accomplish a better working United Nations? Because right now we're seeing too much evidence of it not working.
A question over there. Where? There.
Yeah, thank you so much. It was very interesting. I have two questions. First of all, what is the difference, if there is a difference, between the genocide and the ethnic cleansing? And the second question, I think it's built on the previous question. Do you think in the future there is a possibility for developing some kind of like an international, transnational, like law enforcement, for example, maybe made on the base of the United Nations that would kind of act higher than national armies, so it can actually do something instead of just condemning wars and attacks, and actually would be able to prevent some of them?
So on the first question, the difference between ethnic cleansing and genocide is that with ethnic cleansing, there doesn't need to be that specific intent to destroy in part or whole that group. With genocide, there is. So an ethnic cleansing also often happens when they just want to get the people out, to get them to flee, so to persecute and get them out. So for instance, what happened also with the Rohingya, but now that I'm saying that Rohingya, I think that was a genocide as well. Most ethnic cleansings wouldn't normally be with the intention to destroy. And then, the supranational army. I think that would, I think it is in line with your colleague, with sort of like, to what extent are we an international community? And I think we also see that in Europe, for instance, with the European Union, and the coming to a community is so difficult. And if we see, what other states and therefore other populations are letting happen, and we're looking, we're looking at Ukraine and Gaza, but I haven't talked. Maybe next time I should just not talk about these wars, because there's so many other conflicts and wars with at least as much or very much human suffering that we should also be talking about, and we're not doing anything about. And I think as long as there's no political will to actually make sure that these things don't happen, there will also not be political will to create anything supranational. And a huge challenge with the supranational order, so already the institutions like international courts have been extremely difficult to, and still are, like for instance for a crime of aggression, it's a norm now, but the International Criminal Court can't really do much with that norm. Like, it's made super difficult to apply jurisdictionally. I won't bore you, but so it's the political will to even create an institution that would just speak on law is almost impossible. There are some powerful states that are actively trying to destroy the International Criminal Court. Under Trump, they really were trying to destroy the ICC, and there's lots of pressures going on as well. Other states are trying to do it. And that's a toothless institution that says, yes, that's allowed and that's not allowed, and can't really do much more. An army that isn't in your own control, but that would be allowed to cross your borders when someone external has decided that is justice. I think a lot of small states would be thinking that might be a good idea, to at least think about, but there'll be some not so small states that say, when hell freezes over.
I can imagine there's more questions, but this is our time for today. Maybe, Marieke, you're willing to answer some questions later here
Definitely.
At the beginning. Thank you for shedding light on terms that are used very much in media, online discourse, and not always clear. Still difficult, but it made it a little bit clear. I want to thank you all for being here and hope to see you at another event of Studium Generale. But for now, please give another round of applause to Dr. Marieke de Hoon. Thank you.
Thank you for having me.